We just got back from my son's school because the school suspended my son for 3 days because he put laxatives into a cupcake that a bully stole from him. This bully would constantly shove my kid around and steal his lunch because, quote, he is too fat to enjoy such meals as we send him to school with. So my son decided to outsmart his bully and put laxatives into a cupcake that he knew the bully would steal from him. The bully once again stole my kid's lunch, including the cupcake, and the laxatives took an almost immediate effect. The bully defecated in his pants and then for an hour more defecated in the bathroom. Now let's move on to today for the appeal. My wife and I went to the school in order to defend our son, and wouldn't you know it, the bully and his parents were also there. Why were they there? Well, they wanted my son to face harsher punishment, not just suspension, but expelled from the school. The bully's parents got to speak first, and they got to say their piece, including bringing up the school's zero tolerance for fighting, even when it's retaliation. And that my son should be facing harsher punishment because, quote, my son poisoned their son. And that even though their son forcibly took the cupcake, it was my son's intent for their son to eat that cupcake. That this was thought out and then carried out. And then, just like the scene from White Chicks, I stood up and I said, I started it off with, let's talk about intent. It was not my son's intent to be bullied. It was not my son's intent to have his lunch stolen almost every single day. It was my son's intent, however, to go to school like a normal kid and be left alone. It was my son's intent to stop the bullying without resorting to physical violence. My son reported instances with this child multiple times, and the school did nothing about it, so he had to take it into his own hands. And he did so quite beautifully. My son is no longer fearful of this bully. My son has suffered not only physical pain, but psychological pain from this bully for weeks. And to suggest that my son should be expelled for cleaning out the colon of this bully is absolutely ridiculous, along with him even facing suspension. All across this country, children are doing much, much, much worse things due to bullying, whether it be taking their own life or other kids' lives. And once again, this cupcake was not offered to this kid, nor was it forcibly given to this kid. This kid forcibly took it. My son embodied the phrase, fuck around and find out. And honestly, it is parents like these that create bullies like their son. I'm actually very concerned for this child because God knows what's going on in that household to create such a bully. How dare you? I would never beat my child. I never said anything about beating. My son is now back in school and they are looking into that family. Get fucked, Karen.
Well, all righty then. Okay. That was quite a good story, I thought. I was like, let me share this cute little story with you. I figured you'd want to know. This doesn't look right. This looks just wrong. Just wrongness. That's way better. That's way. Don't you like that better? I like it better. Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. It is my pleasure to be with you here this evening. Let me just make sure everything's fired up and working all around the internets. Are we good everywhere? It's looking like we're good. It's looking like we're good. All right. Excellent. Tonight we are covering a couple of indictments. We're talking about the Comey indictment. We're talking about Anthony Fauci's co-worker there being indicted for his COVID-19 cover-up. Now, with respect to these stories, I plan on actually covering them like a little bit differently. I'm going to talk to you about the viability of each of these indictments, how good, how weak they look, but I have like different thoughts about them. I have different thoughts about the Comey indictment and the Morenz, the gentleman the doctor who was arrested. His name David Morenz. So he's the associate of Dr. Fauci. I have a lot of thoughts about this and questions we're going to examine. Do we think that this is ultimately going to lead to an indictment of Dr. Fauci himself? We know that Dr. Fauci got an auto pen pardon, which to me, the flaw in his pardon is much less that it's an auto pen, although that that really should be a pretty serious flaw if there was not proper intent. But the broad nature of it seems ridiculous and something that shouldn't be legally binding. And I'd love to see that thing get tested out on him. I'd love to see it. So we're going to see whether or not the indictment actually looks as if it might lead a little higher up the food chain to Dr. Anthony Fauci. All that, and if we hit tonight's goal, which is our normal goal of 15 super chats or more in quantities of $10 or more, if we hit that, then we will go into hour 3, and this is what I'm going to be giving you in hour 3. In hour 3, I'm going to be covering Mamdani, how he's destroying New York City. And also, I'm going to be drafting more pages of the Good Lawgic manifesto. If you missed last night's show, I started drafting a manifesto, recognizing that in the event situations unfold, which I recognize it's time for me to go off half-cocked, I'm going to need to have a manifesto primed and ready to go. See, yesterday, I started writing my manifesto. And I think that AI was doing it after much prodding for myself, started actually doing a pretty good job of writing a really manifesto-ish manifesto. Pretty good manifesto. People seem to really enjoy it. So I'm willing to go back to that. If you have suggestions that you want to drop for me as to like different topics I should be covering as we continue the draft of my manifesto, I'm all ears. I'm right here. I'm right here. That is if we hit tonight's goal, which again is 15 super chats. Doesn't have to be super chats. It could be Rumble Rants. It could be Digger Dollars. It could be someone decides, hey, let me just Venmo. Let me just kick it out at Joe. I'll take it. That'll work. Okay. PayPal. PayPal's always good. Don't underestimate PayPal. Do not sell PayPal short. So I think some of you are selling PayPal a little short. Don't sell it short. Don't sell it short. That's good. All right. So all that and more coming up. So I urge you to stick around, stick with me as we cover tonight's developing stories. I do have a lot on Mamdani. I do. I have a lot on Mamdani. Some good stuff. I also have some stuff on Minnesota, things happening in Minnesota. I feel as if I talk about Minnesota like way more than I should. Way more than a state that has fewer than 15 electoral votes. What do they got? 10? 10? And I feel as if I'm talking about Minnesota all the time, whether it's Ilhan Omar, Minnesota fraud, Tim Walz. I feel as if I can't stop talking about Minnesota. It's very, very aggravating, but there's more and more news coming out. More and more news there was all sorts of DOJ, FBI investigations going on in those Leering centers. But we're gonna put a pin on that for another day. A pin on that for another day. Yes, topics. I'm going to let you recommend to me that if we hit our goal, different topics you want me to cover in my manifesto. Yesterday, we talked about the Jews and a little bit about the Jews and also neocons. We started touching on that. I feel like this manifesto, I'm really enjoying the way it's coming out. I'm really enjoying it. I'm feeling like, it's a good thing to have in the back pocket. I'll just leave it there. I'm going to start off by talking about Mr. James Comey. I have a feeling I might disagree with some of you about James Comey here. Some of the stuff on James Comey. This is the report that was brought down by CNN when they first were learning of the James Comey indictment, which they're not too happy about. Not too happy about it at all.
I don't know the charges, but we do know what this is related to. Again, remember the first indictment was about him lying to Congress and these leaks to the press. That has nothing to do with this indictment. We are told that this has to do with the case that you heard Caitlin Polans talking about earlier, this investigation from Secret Service into Comey's social media post that he posted a picture on the beach of seashells that said 8647. And
now I'm going to ask you right now. You can weigh in. I'd love to see you weigh in. Do you think that him posting or anyone posting, because you can't just focus on James Comey individually, that someone who posts a snapshot of a picture that says 8647, that is something that they should be charged? Do you think that's a violation of his free speech? Do you think that that's, a good thing we should be pressing, a bad thing? Give me your feedback on that. Feel free to weigh in, because that's what he did. He basically seemed to arrange some seashells into the numbers 8647, understanding that 86 seems like it's a reference to, kill him or end him or finish him. Really could mean any of those. 47 is a common reference to, obviously, Donald Trump. And the question is this something that you think he should be prosecuted for?
He deleted that post, but at the time, Republicans said that he was trying to incite violence against President Trump using that kind of social media post there. Now, I will tell.
And we really can't ignore the timing of this, right? I mean, the timing of this is it's right after the indictment drops, right after there was an attempted assassination of the president, which the left loves to pretend and says, well, we don't know who he was trying to kill. Even we don't know the we don't really know the motives. Oh, until such time as it's clear, we really should slow it down until we know the motives. According to Barack Obama, he's got a manifesto, and post after post is talking about how Trump is a threat to humanity, but we don't really know the motives. It's a little premature. He's quoting people that, Barack Obama himself likely would be retweeting if he wouldn't be so too embarrassed. And all these lunatics who are continually referring to Trump as being Hitler, fascist, baby killer, rapist, whatever it is that they want to make up about him. So that's what he's sharing out, but we don't know the motives. It's hard to know.
You that the source that I spoke to directly correlated this to what happened on Saturday night, saying we've already seen all of this incitement of violence. We just saw it again on Saturday night. Not that these two things were directly related, but referencing the event on Saturday night while talking about this indictment in particular and the case around this social media post. It will be interesting to hear what we hear from the Justice Department on this, if there is any kind of actual correlation talking about this incitement of violence. But it also comes at a point where we are hearing from this White House nonstop saying that this is all about political rhetoric, that the reason that there have been so many assassination attempts have been because of rhetoric against President Trump.
Like rhetoric like from CNN.
Obviously, we know that rhetoric on both sides of the aisle.
No, we don't know that. That's stupid. Give us examples of the last time that someone from the right tried engaging in an assassination. Give us one example of someone from the right. Give us the last time. Because if you're talking about an assassination, like an assassination, I'm not talking like an assassination. Tell us the last time it happened. Because the last time we saw that is probably before I was born. What's it? RFK? Probably someone from the right, right? CERN. It's probably someone from the right. We haven't seen this in generations. So, no, what the hell are you talking about?
Has been increasingly violent in this political environment that we are currently in. But that is what we know so far about the current indictment against James Comey, that this is about that social media post, which at the time the Secret Service said that they were going to investigate.
Kristen, thank you so much for that report.
I like how they had this random shot of some hall in the middle of somewhere. I don't know if it's the Capitol. I don't know where it is. A bunch of folks walking around there.
Reporting, Caitlin Polance is with us now. So, Caitlin,
is that supposed to be like King Charles addressing Congress? Is that
the sourcing indicates that this is over that 8647 post that James Comey published online now years ago. There's no indication, there's no evidence at this point that we're...
It's not years ago, it was last year.
...aware of that's in the public, that post had anything to do with what happened on Saturday night, correct?
Correct. Boris, that post was from May of 2025. So
years ago. 11 months / years ago. I feel as if I'm going to struggle to maintain eye contact with this woman. I don't know who she is, but I feel as if I'm going to struggle to maintain eye contact.
Several months ago, almost a year ago. And at the time, what happened, I was just going back to remember exactly how this went down. Comey posted it. 86-47 people who were Trump allies and Republicans responded to it, initially believing that it was a call to potentially assassinate the president. 86 is what is commonly used in restaurant speak to say when something is out or no more, and 47 would be the 47th president. The Seashell Post back in May of 2025, James Comey, after this was posted, after there was blowback from Republicans and people who were allied with Donald Trump, he took the post down and he said publicly, I didn't realize some folks associate those numbers with violence.
I didn't know. The I didn't know defense. All right.
It never occurred to me, but I oppose violence of any kind, so I took the post down. But the Department of Homeland Security Secretary at the time, Kristi Noem, she said that she did want to have Comey investigated for the assassination, for calling for an assassination.
Anyhow, JH says the 86-47 Comey crap is weak and stupid. Rico, he needs to go down as a conspirator to take down the government. Yo, I agree with you on that. And my initial take on this is, what are we doing? What are we doing? Is this really what we want to be like trying to charge people for? Is this really what we want to do? I don't like it. Is it technically a crime? Yeah. He's done so many worse things. It feels as if like this way we can say we're going after Comey. And, you know, we can get popular opinion behind us because of the recent assassination attempt. I don't like it. I don't like it. Let's look at it. Let's look at it together. We'll take a look at the indictment here. Before I do that, let me just not ignore the ghetto. Uzelian sent a $10 rant, so that counts toward the goal because rants count. Rants definitely count. Saying, Joe, I can't wait to renew my passport to the new one. Also, you forgot the trans. What in my manifesto? I can include the trans. Open link, new window. He's got a link here for me to check out. This is the new. This is great. I didn't even see this. Thank you for sharing this with me, Zelly. This is the new one. That's fun. Fun times. All right. Here's our indictment of James Comey. The grand jury charges a very short indictment, only 3 pages. On or about May 15, 2025. We'll call it the Eastern District of North Carolina. Defendant James Bryan Comey Jr. did knowingly and willfully make a threat to take the life of and to inflict bodily harm upon the President of the United States. All right. We'll do underline. Oh, that's not what I know. Let's just do a drawing. Okay. In that he publicly posted a photograph on the internet social media site Instagram, which depicts seashells arranged in the pattern making out 86-47, which a reasonable recipient who's familiar with the circumstances would interpret as a serious expression of an intent to do harm to the President of the United States. The violation of Title 18 United States Code Section 871 on or about May 15, 2025 in the Eastern District of North Carolina, which that is where this is. He was indicted, the Eastern District of North Carolina. That Comey knowingly and willfully did transmit interstate and foreign commerce communication that contain a threat to kill the president. And that is something you cannot do. Specifically by publicly posting a photograph on the internet social media site of Instagram, which depicted seashells arranged in a pattern making out 8647, which the recipient is familiar with the circumstances, would say, again, serious expression of intent to harm. In violation thereof, now it is hereby given that all right, title, and interest in the property described here is subject to forfeiture. What? In the property described? Which property are you referring to? What is this about? Upon conviction of any offense charged herein constituting specified unlawful activity or a conspiracy to commit such offense, the defendant shall forfeit to the United States pursuant to 18 U.S.C. 981 and made applicable by 28 U.S.C. 2461C any property real person which constitutes derived from proceeds traceable to the said offense. I don't think he made any money off that post. I can't even believe it. If any of the above described forfeitable property is a result of any act or commission, I think this is just, we don't want to have a one-page indictment. That's what I'm thinking. Because what did he make already? What did he make from it? Has been transferred or sold, be deposited, third parties been placed beyond jurisdiction of the court, has been substantially diminished in value, or has been commingled with other property which cannot be divided without difficulty. It is the intent of the U.S. pursuant to Title 21 to seek forfeiture of any other property of said defendant up to the value of the forfeitable property. This is all right. I'm struggling with this. Look, I hate James Comey as much as the next red-blooded American. I do. But maybe Todd Blanche can sell me on it. Let's listen to Todd Blanche talking about it.
Today, a grand jury sitting in the Eastern District of North Carolina returned an indictment against James Comey on 2 counts. The first count is that on or about May 15th of last year, he knowingly and willfully making a threat to take the life of and to inflict bodily harm upon the President of the United States. Count 2, same day, May 15th, 2025, that the defendant, James Comey, knowingly and willfully transmitting in interstate commerce a communication that contained a threat to kill the President of the United States. Both of these counts carry a maximum.
Robert Gervais says that it can be considered true threat, not protected free speech. Look up SCOTUS decision in Counterman v. Colorado for ruling on this. This can stick in North Carolina federal court. SCOTUS precedents. Counterman v. Colorado. I'll try to pull that up while we play this clip of Todd Blanche.
Term of imprisonment of 10 years. So I think it's fair to say that threatening the life of anybody is dangerous and potentially a crime. Threatening the life of the President of the United States will never be tolerated by the Department of Justice. Over the past year, this department has charged dozens of cases involving threats against all sorts of individuals. We take these seriously, every single one of them. For example, just today in the Northern District of Florida, there was a guilty plea from an individual who threatened multiple political leaders, including President Trump. In the Eastern District of North Carolina, where this case was indicted earlier today, there are multiple threats cases very similar to this one, including one where the defendant pled guilty recently to threatening former President Biden, another one that's scheduled to go to trial this summer, another one indicted, an individual was indicted for threatening Tom Homan. I say that to say that
he's trying to say it's not politically motivated, that we're going seriously after all of these people. This is designed to basically say, hey, don't think that we're just targeting Comey because it's Comey. We go after anyone. Even they go after Homan or other folks.
While this case is unique and this indictment stands out because of the name of the defendant, his alleged conduct is the same kind of conduct that we will never tolerate and that we will always investigate and regularly prosecute. I want to take a moment to
He's got to work on the heavy breathing, just as a professional speaking tip.
to thank the hardworking members of the FBI who investigated this case over the past
1,000 times better than what's her face, than Pam Blondie, but we gotta get there.
11 months or so. The United States Secret Service, who also assisted in this investigation, and the United States Attorney's Office for the Eastern District of North Carolina, led by United States Attorney Ellis Boyle, who's standing to my right. This was an investigation that remains ongoing. That's been ongoing for about a year.
Okay, you're saying he was promoting his book and made a viral post in order to call attention to it. That's an interesting thought. That would explain the forfeiture. That would explain the forfeiture. It's a slim nexus in the sense that you have to establish that that was why he, that unless you have witnesses which are able to tie that together. And they talk about some witnesses that they have. I think he mentions it in this press conference. But to say, you have to sort of tie in that there's a motivation here that he's trying to, get people talking about him publicly for the purposes of promoting his book. I just think that that's could be. I guess now I understand why you charge it. I just think it's tough. 8647 is baby poop out one grown-up cases. Do you think that they will go after Comey over anything just like they did Trump? It's the process of defending all accusations. It seems like they will, right? It seems, but why not after the real stuff? We all want to see that Operation Crossfire Hurricane. We all want to see that one. We all want to see him and Brennan and Clapper as co-defendants. I don't want to see this. I feel as if you owe me like a Mercedes and you're giving me a bicycle. And be like, hey, look, I got your transportation. And I'm supposed to be getting a Mercedes. This is just not. But that doesn't mean it can't work, but we'll hear the other side of the coin.
And that's all we're going to say about it today. I will let the U.S. Attorney Boyle speak now, and then after that, Director Patel. Thank you.
Thank you, Mr. Attorney General. Earlier today, a grand jury in the Eastern District of North Carolina returned a true bill indicting Mr. James Comey with committing 2 felonies. Count 1, he knowingly and willfully made a threat to kill and to inflict bodily harm upon the President of the United States in violation of 18 U.S.C. 871A. Count 2, he knowingly and willfully transmitted in interstate and foreign commerce a communication that contained a threat to kill President Trump in violation of 18 U.S.C. 875C. Mr. Comey will be given every form of due process all citizens are entitled to receive, to include a trial by a jury of his peers. In the Eastern District of North Carolina, it doesn't matter who you are. We take all threat cases seriously and prosecute anyone who violates federal law, regardless of title or status. Thank you.
So, and I do think that there's an attempt to differentiate from Pam Bondi saying, see, we're going after someone who's a serious person.
Thank you. As you heard from the Attorney General and the U.S. Attorney, former FBI Director James Comey has now been indicted for 2 felony counts. While many of you may read this indictment and view this matter as a simple investigation, it is the farthest thing from that. Every single investigation this FBI and our partners at the Department of Justice undertake, especially those that involve the threats to harm or hurt or even kill individuals, whether they hold public office or civilians in our country, are met with the same measure of investigative prowess and tools and personnel in partnership with the Department of Justice as anyone else. As the U.S. Attorney indicated, James Comey will be afforded every matter of due process under the United States Constitution. And as the Attorney General indicated, this has been a case that's been investigated over the past 9, 10, 11 months. These cases take time. Our investigators work methodically. They are career agents.
If it took you 11 months to come up with this 3-page indictment against Comey, it feels as if it'll take you like 9 years to go after Brennan, Clapper, Obama. Right? I mean, 11 months.
Career prosecutors who work these matters, they call the balls and strikes in the field as they see fit pursuant to the facts of the case and the law. They took that information and made a presentment to a grand jury, a jury of peers in the district.
Is it just me, or does his suit look particularly shiny? It's a very unusual suit.
The alleged crime took place, and that grand jury spoke, and that grand jury returned a 2-count indictment against James Comey. James Comey allegedly threatened the life of the President of the United States, and as you all now know, shortly after posting that threat, he deleted that threat and then issued an apology. All of that information was presented to the grand jury, and Mr. Comey will have his day in court and his ability to speak to a jury of his peers. Thank you.
Maybe, I don't know.
Thank you. We'll just take a couple of questions.
Mr. Attorney General, the Justice Department in this filing today also issued an arrest warrant for Mr. Comey. Is it your belief that he is a continued public threat? And is there a request also for detention that you anticipate will be made in this case?
So the Department of Justice does not issue arrest warrants, grand juries do. And so the grand jury returned an indictment and arrest warrant. I expect that there will be communication with Mr. Comey's counsel, and we'll go from there. This case will proceed like hundreds of others do every year. There will be some sort of arraignment set by the judge or assigned to the magistrate judge, and when that happens, you'll know about it.
But in this is being handled differently from the last time he was indicted. That's my reference. In this case, the department requested an arrest warrant, right?
Well, I don't think that it's public or clear what the department requested. The grand jury issued an
I think the objective, Viola, is to try and make, and it's good to see you, is to try and make a unified front. It's to project strength, I think. That's why they have, I mean, I don't know why Cash has to be there, but it's to show unification, I guess.
arrest warrant. Yes.
Sir, how will you prove intent when, as the director had acknowledged, Mr. Comey said he did not associate 86 with doing harm, and he
This is a very good question. This is a very, very good question.
took it down promptly, said it was political speech, not an intent to harm the president?
Well, it's not, this case was indicted today. This conduct occurred about a year ago, May 15th of last year. There's been a tremendous amount of investigation. And how do you prove intent in any case? You prove intent with witnesses, with documents, with the defendant himself to the extent it's appropriate. And
Right. I mean, you're not going to get him to testify. I guess other statements he might have made.
that's how we'll improve intent in this case. And so I think that talking about what Mr. Comey will or will not do if there's a trial, when there's a trial, it's very premature for me to do that today.
General Blanch, I want to ask you a quick question about, there's a number of other different types of conduct Comey has been accused of over the past. One of them is abuse of FISA warrants. I wanted to ask if there's anything that we could talk about today in regards to that, but on a separate matter, if I may ask any more updates about the ballistics forensics analysis with the shooting that happened over the weekend.
So on the first question, no, there's nothing else to report about any investigations or anything involving Mr. Comey except the indictment that was returned today by the grand jury. I don't have anything further to talk about with the ballistics that are still being analyzed. And I said it yesterday.
I will ask you this, because I see you in the audience here. Defending Comey. If not, what do you think he could have possibly meant beyond that? And let's bear in mind, as Kimmy pointed out, she brought up, which she probably got this from Robert Gouveia. If she didn't, then kudos to all the more kudos to her. But even just bringing it up is a good case. Good case to bring up is Counterman v. Colorado, which I didn't pull up the case itself because I was like, I can't start digesting that in the middle. But I did get a synopsis. Bondi Stonewall Counterman v. Colorado ruling. I was just going there. So in Counterman v. Colorado, you have this Billy Raymond Counterman repeatedly contacting a person over Facebook in 2014, sending creepy messages from numerous different accounts. She blocks him. Some of the messages imply that he's watching her, saying he wants her to die or be killed. She reported Counterman to law enforcement. They arrested him. He was charged with 1 count of stalking, 1 count of stalking. It's a credible threat, 1 as serious emotional distress, and 1 count of harassment. For trial, prosecution dismissed the count of stalking. Counterman claimed that the remaining charges, as applied to his Facebook messages, would violate his right to free speech under the First Amendment because they were not true threats. The trial court denied his motion to dismiss and found him guilty of stalking. Now the question is, was this free speech? So the question is, to establish that a statement is true threat unprotected by the First Amendment, must the government show the speaker subjectively knew or intended the threatening nature of the statement? So they have to show that he knew this would be threatening. And the answer is no. To establish that a statement is a true threat unprotected by the First Amendment, the government must prove the defendant had some subjective understanding of the statement's threatening nature, based on a showing no more demanding than recklessness. This was written. The left is the one who went after him hard. Obviously, joined by some folks in the middle. One of the people who dissented and is more in favor of free speech is Judge Clarence Thomas. While the First Amendment protects freedom of speech, it allows for restrictions to so-called true threats, and the true threat is determined by the recipient's perception, not the speaker's intent. So we don't care what he thought. We don't really care what Comey thought 86 meant. We care more about the perception of the recipient. However, to prevent chilling protected speech, there must be a subjective mental state requirement. What does that mean? That the speaker's understanding of the threat is crucial, a recklessness standard. So it's a very, very reckless is about as low as you can have for forming intent. If you were reckless in it, where a person consciously disregards a significant risk that their words might harm another, is the appropriate measure for true threats because it strikes a balance between safeguarding free speech and addressing genuine threats. Now, I don't think that we take into a factor here. You and I would likely agree that there's almost no chance that Trump felt that Comey was threatening that he was going to kill him. Let's assume that that's the case, right? That we can all come to that conclusion. I don't know that his subjective situation, that he's protected by Secret Service or the age of James Comey, is something that would play in here. But I don't know that. I don't know that to be the case. In Counterman's case, the government used only an objective standard without considering Counterman's understanding of his statements as threatening, in violation of other requirements of the First Amendment. So Sotomayor authored an opinion concurring in part and concurring the judgment, which Neil Gorsuch joined in part. Sotomayor would not reach the question whether recklessness is sufficient for true threats prosecution generally. Thomas authored a dissent opinion criticizing the majority for relying on New York Times v. Sullivan instead of applying the First Amendment as it was understood at the time of its founding. And Barrett authored a dissenting opinion which Justice Thomas joined, arguing that true threats do not enjoy First Amendment protection, and nearly every other category of unprotected speech may be restricted under an objective standard. So, if it's a true threat, so actually, let me strike what I said earlier. So they're basically saying if it's a true threat, the left let him go. I want to correct what I said earlier. I was mistaken in how I digested this off camera very quickly. So left basically let him go, saying you failed to establish that he had any understanding that these were dangerous, an objective standard that he showed his recklessness. And Thomas and Barrett were basically saying, Barrett's like, we don't have any there's no First Amendment rights when it comes to issuing a threat. So I will share with you I have here. Where are you? Jonathan Turley talking about how the state's likely to struggle here.
Create opportunity for yourself and others. Earn an accredited degree online at wgu.edu.
Bring in Fox News contributor, constitutional law attorney Jonathan Turley. Jonathan, when Comey initially posted that Instagram photo, his caption insinuated that he did not create this shell art formation in the sand. I'm curious.
I don't know if that's relevant.
If it matters, whether, he got a lot of criticism at the time. Everyone was saying, oh, we all know that you actually put that together and then photographed it. Does any of that matter in a legal sense in this case, whether Comey is the originator of that message or whether he just walked by, as he claims to have done, and photographed it?
Well, I have to say, I must be in a parallel universe to be talking about the shell artwork of James Comey. But the fact is that it is relevant only to the extent that he might have denied a fact that proved his denial proved to be false to federal officials. In the original,
sorry to stop you, but you mean like if there was a witness or something on the beach who saw him? Is that what you're kind of alluding to?
Well, if he was questioned and gave false information to federal investigators, that can be the basis of a charge. I think that just showing the picture is going to be a weak case in terms of a threat. What's interesting is that the first indictment that was dismissed involved false statements under 18 U.S.C. 1001. And that's the most used provision in terms of false statement prosecutions by the Department of Justice. What's interesting about that dismissal is that it was based on the fact that Lindsay Halligan, who was the acting U.S. attorney, was viewed as not properly in her position.
Which was ridiculous. That was just ridiculous. That was utterly ridiculous.
That problem has now been cured by James Hundley, who is appointed essentially by the court. Now, it's not clear if they went back and just cured that problem, they're going to reissue part of what they were pursuing under the original indictment, or whether we're talking at this point of something that is a new charge.
So, Professor, we don't yet know what the contents of the indictment hold, but Kerry Urban posits that it may be charges under 18 U.S.C. 871, which makes it a federal crime to knowingly and willfully mail or make any threat to kill, kidnap, or inflict bodily harm upon the president, vice president, or their successors. There may also be a charge under a transmission clause of 18 U.S.C. subsection 871.
And he was charged with 871.
Showing a picture of shells that say 8647, is that, I mean, that could be taken as a threat, but does it amount to one to you?
In my view, it would very likely be viewed as protected speech if it was the basis of a criminal indictment. That alone would have a hard time standing up in court. I've seen that reporting, and we'll have to see how they would stick that landing in an indictment. But just showing a picture like that it would be a very difficult foundation, a very unstable foundation for a prosecution, because right out of the gate will come a First Amendment challenge that the court, I think, would consider first and foremost.
Whisper.
All right, Jonathan, stand by. Thanks for jumping.
All right. Well, anyhow. I think this is a tough case. I think this is a tough case. I'm not saying it's impossible, and I'm not crazy about this case. I just feel as if it's trying too hard, and it's trying too hard to give MAGA a win. That's what it feels like to me. It feels like it's trying too hard to give MAGA a win. And I don't like that because it feels that makes it like, persecution rather than prosecution. So, yeah, I think that you can show that he's being reckless, that in the sense that he knows that that anyone would recognize that 86 means kill. I mean, that's what it means. It doesn't, he could argue it means get rid of, I guess, like, politically get rid of, but what would that even mean? Impeach? Anyway, we got a little bit more here from Todd Blanche. Oh, let me just get this. Rizalian says the problem is it's too soon to be him, and this hadn't started under Bondi. Let's not pretend it's because of John. Problem is it's too soon to be him, and that this hadn't started under Bondi. Let's not pretend it's because of John. Not sure what you mean by that. Too soon to be him. It's too soon to be Todd Blanche. Hands One Pack says maybe these were charges that Pam was blocking, and now that she's gone, they're dropping him. That's possible. That's a fair theory. It's a reasonable theory to throw out there. We'll never know. But it's a reasonable theory to throw out there.
And every law enforcement member who is speaking on this issue is saying the same thing as they should, which is that this is an ongoing investigation with really, really smart experts trying to understand what happened in that shooting and where the bullets went and ended up and where the bullets came from. And once that is at a place where we can definitively say, to the extent we can definitively say, we will let you know.
Director Comey posted this almost a year ago. Why bring this case now? Did you always feel like this was a strong prosecution, or did something change recently?
This investigation just didn't come now. It's the result of a lot of work by law enforcement over the past year. We don't time when we bring cases around anything other than when the investigation is at a place where we should go to the grand jury, and that's exactly what we did in this case as well.
As a former FBI director, you may not agree with what he did. Should he be able to turn himself in as a former FBI director? He's not a flight risk.
I didn't say he can't turn himself in.
So he's not under arrest right now, and he may be able to.
I don't know whether he's under arrest right now. I'm here talking to you. The grand jury issued an arrest warrant. I think that the way that this happens is different in every case. It's fact intensive. It depends on you're right, who the defendant is. It depends on whether he has counsel. It depends on what the judge wants done. And so I don't know when the judge will schedule an initial arraignment, if that will be scheduled by the magistrate or the district court judge. I am sure, I don't know if you want to speak to that, or if it's just something that will come up in the next coming days. You'll know when it happens. As far as what Mr. Comey does between now and then, I'm going to leave that up to the line prosecutors in the Eastern District of North Carolina, the FBI agents, and the work that they're doing.
Why, Director Patel, maybe you said that it's a complicated thing. A lot of people might think it's an easy case. Why did it take so long? I know that
it's not an easy case. It's an easy case to charge if you're so inclined to charge it. But I think this is a fair question. Why the heck did it take so long?
You guys chose to go with this now, but to the layman just looking at this case, or layperson looking at the case, it was an Instagram post. He apologized. Why did it take so long?
The apology is irrelevant.
Well, I'm not going to get into the details of the investigation itself, but a lot of these cases, you could look at when the threats were made and when charges are brought. They're not easy cases. And so we have to, there's a communication that's sent in allegedly in this case. And so that means that we have to look at devices.
The question is looking for an answer that Pam Bondi was stonewalling it. That was the question was looking for. Because it's a reasonable theory.
Mr. Comey is a lawyer. He has lawyers. So to the extent that we're looking at materials that are potentially privileged, we have to get a wall, set up a wall and let totally independent lawyers look at those. And so that doesn't happen overnight or quickly. And the statute of limitations of this is 5 years. We brought it in under 1 year. So that's really where we're at.
The problem with what you're suggesting here, Kimmy, is that's a claim really of incitement. That the target, if you're going to say the target is his crazies, then you're looking under an argument of incitement. And if you're looking under an argument of incitement, you have a weak, first and foremost, that's not what he was charged with, right? He's charged with making a threat at Trump, not with inciting people to harm him. So, and if it's incitement, in that case, you know, you have to show a clear and imminent threat. There's got to be imminence with respect to the time and you know, for the ability for them to someone to actually harm him. And I don't think they have that. They're unlikely to have that. So the audience being the crazy is not Trump is something that the state cannot make a claim about, even if that was what his objective was. And if it was his objective in that case, and if he claims that was his objective, that's probably like something that I think can be used as a defense, because he's not charged with trying to incite the assassination. He's charged with threatening that he's going to, or someone is going to. It's a different charge. So with all this petty stuff, the DOJ better go after Madonna, Johnny Depp, and the others that made stupid statements. Well, they said that they went after others. They certainly didn't go after Kathy Griffin with her whole headless Trump thing. You know, they could have. They didn't. To me, the headless Trump is way more of a threatening message. It's way more of a lunatic, deranged type of message than 8647. Now, obviously, that's beyond the statute of limitations at this point. But Kathy Griffin, what she did was way worse, in my opinion. Am I the only one who thinks that? It can't be.
It's clear that you don't want to talk specifics today. But to the American public, can you at least give us a sense of whether you have hard evidence or evidence that shows that Mr. Comey intended for President Trump to be harmed? And then secondarily, for critics who say, where does free speech end and an actual threat of violence begin? I don't know what critics say that, especially today, but it's not a very difficult line to look at. And it's not, in my mind, a difficult line for one to cross over one way or the other. You are not allowed to threaten the President of the United States of America. That's not my decision. That's Congress's decision in a statute that they passed that we charge multiple times a year. And so whether there is a defense, as you just described, maybe there is, but the government will have evidence. I am not going to talk about the evidence that we have. That's unfair to him. It's unfair to the prosecutor.
Attacking the statute as being unconstitutional, which is what many of you are likely thinking, it's so well entrenched and it's so well protected that I think that that's a loser battle. If you have to try to attack the statute as being, you know, an American violation of First Amendment, they should be allowed to threaten the president because of free speech. That's a losing argument. You can't even threaten some rando, much less the president. It's a special punishment for the president.
But it's enough to say that the grand jury returned an indictment. I'm just take one more question.
Thank you, sir. Mary Margaret with the Daily Wire. Should we expect more indictments of this sort? For example, in 2020, Gretchen Whitmer did a TV hit with 8645 on her desk in the background. Is that the kind of thing you would pursue? And then just really quickly, should Comey expect to face more charges for his role in the Russia collusion investigations?
I think that's a good question too. Is this like a new thing? Because no one did this before. We didn't see it in his first term.
I'm not going to comment on other investigations involving Mr. Comey. He was indicted in the Eastern District of Virginia. That was dismissed on procedural grounds because of the judge's finding regarding the U.S. attorney. So that case is under appeal. As far as other investigations that are happening, it would not be appropriate or fair for me to comment on that time. As far as other incidents of threats against the President of the United States, those will be investigated. Every case is different. The facts are different. Who makes the threat matters. What the threat says matters. You're right. The question about intent matters, and we have to prove that. That's something that's our job, and that's something that prosecutors will have to do in front of a jury at the right time. But you cannot compare. It's not fair to the American people. It's not fair to the defendant. And it's certainly not fair to the prosecutors to compare, well, if you did it here, why didn't you do it there? Every case is different, but there's one thing that will never be different, which is that you cannot threaten to kill the president of the United States. Full stop. All right, thanks a lot, guys.
You're just listening in there, Acting Attorney General Todd Blanche, as well as others, including the current
And what that basically, what's the $1 million question is, what is deemed a threat, right? I mean, that's really what the $1 million question is. What is deemed a threat? 8647 to me is really, it's a stretch. It's a little bit of a stretch. I don't know. That's just me. I think it's a bit of a stretch. And there's so much more that he richly deserves prison for, that I feel as if this is a stretch designed to say, this is where we're going after him, not for the real stuff. So I'm not really that excited by this. Does that mean that it's impossible for him to be convicted? No, I'm not going to say it's impossible for him to be convicted. I'm just not crazy about these charges. I think that there's a lot more and better work to be done by the DOJ. And some post from 11 months ago was saying 8647. But I don't run the DOJ, and I don't have to answer to Trump either. So who knows? Who knows? I do want to talk to you all. What are we doing on our goal? How's our goal? In case you're wondering about tonight's goal, I'll talk to you all. I just want to tell you, even though you might see up in YouTube, it looks like 4. It's actually, we're at 6. We're closer on the goal than you think. Tonight's goal, if we hit 15 super chats or Rumble rants, they count too, like I said, of $10 or more. And I forgot that I have on locals also, because the locals, J.H. Schwalbeck sent me, oh my gosh, sent 2. First one said, Joey, Joeisha for my black friends. Joey, I got my very first X alert DM from some guy at the Following Pro. It's true, he did. Telling me when you would be on tonight. I love this guy, no homo. Keep tickling more. I want more of this. And then he sent a second one for 25. Over here. Joe, Mama, yo, Joe. If you could please give me a Saturday night Gouveia Branca Neerman show once a month, 2 times. I think it would be magical. Plus, I would be your Hoizbacher. Your Hoizbacher? I don't even know what that, I don't know what Hoiz means over here. If you could do this, or I could just keep sending you my grandchildren's inheritance, just make it happen, please. I don't know that I can get Gouveia on so often. He doesn't like to work late at night. He never told me that, but it's not easy to get him on. He's a very busy man. He works really hard. He's churning out tons of content. Great content. He's awesome. I don't know that I could just get him in here. Certainly not to commit to come a couple times a month. That's not going to happen. That much I know. I'd love to have him, but that's not going to happen. So as I was saying, with respect to tonight's goal, you might see, if you look in YouTube, you get all depressed. You're like, well, it's only 4 out of 15. No, we're at 8. We're at 8. And so that's awesome, right? I mean, that's very solid. And you know that I'm trying to err on your side. If we hit tonight's goal of 15 super chats, $10 more, in that case, tonight we will have hour 3, where I will continue adding on to the Good Lawgic manifesto, where I am writing my manifesto to be unleashed on the world for when event X happens, when questions need to be answered and I'm in cuffs, and when I'm unable to answer them, that I will leave behind a record for the world as to what it was that set everything in motion. Plus, I'll also break down for you Mom Danny and just how badly he is destroying the city of New York, which is pretty bad. It's pretty bad. But for now, we need to get into Dr. Fauci. Or more specifically, his co-worker, his underling, David Morenz. We'll start here with this.
Department of Justice has dished out a shocking indictment accusing a former senior advisor to Dr. Anthony Fauci for allegedly concealing records amid probes into the origins of the COVID-19 pandemic.
And I caution you, I know the voice here is, this is the least boring voice I was able to find, which did a little breakdown of this story. But this is David Morenz that you see here on the screen. He has been arrested for covering up the origins of COVID-19, despite FOIA requests, which were sent to him saying, hey, we want to know about the origins and what you said to your peers, and that he was willfully destroying them.
78-year-old David
Allegedly.
Morenz has been charged with conspiracy against the United States, destruction, alteration, or falsification of records in federal investigations, concealment, removal, or mutilation of records, and aiding and abetting. The indictment.
And the question that every one of us should have is, will this lead to charges against Dr. Fauci? Because that man is basically, for my money, I'm just sharing with you my personal opinion. I cannot prove this to be true, but I believe he is Satan, and that he's someone who is basically was dropped here by demonic forces to try and destroy humanity. So, and beagles, because he can. So yes, I think that he is a terribly, I can't prove it. I can't prove it's true that he's of demonic origin. I cannot prove that. So in case people are looking to, like, you know, in case there's a libel suit that comes down the road and he decides to sue me for saying that he comes from demonic origin, I just want to be clear. You know, it's a statement of opinion. It's not a statement of fact, but we know. But we know, right? I'm just saying.
Which was unsealed on April 27th in Maryland federal court.
The cloven hooves are always a giveaway, right?
Lists two unnamed co-conspirators who, quote, concealed, removed, destroyed, and caused the concealment and removal of federal records to evade the Freedom of Information Act and the Federal Records Act. According to communications first exposed by the Post in May 2024.
Who was he aiding and abetting? I wonder if Todd Blanche is the man who's willing to challenge blanket pardons. I started talking about this earlier, and I just want to pause and share with you this. In case you've forgotten, Dr. Anthony Fauci was conferred upon him, either by hand or by auto pen, courtesy of Joe Biden, a blanket pardon for everything he did related to COVID-19. I do not believe that is legally effective. I think it's a legal nullity. It happens to be de facto effective more than de jure effective, in my personal opinion. What do I mean by that? Well, this has never been tested in law, whether or not a president has the power to say any crime associated with X is, I'm hereby pardoning you. For my money, I do not think a president has that power. I think a president has a power to list off 10,000 crimes and say, I'm pardoning this individual for these 10,000 crimes. He can pardon him for whatever crimes he wants. His pardon power is plenary, but he's pardoning the sin that the person committed. He is not washing that person and cleansing them, saying you're hereby holy and no longer can be charged for anything you've ever done. I don't think that works. I think that he has to have mens rea onto the intent to understand what it is that he's pardoning. The fact that we allow him to pardon for any crime, it says he can pardon for any crime, it doesn't say he can pardon any person. Those are two different things. So he can pardon any offense that he likes, any federal offense that he likes. Great. But you cannot pardon a person. And if you cannot pardon a person, then just, and the reason this is the reason it's illogical to think that he can pardon a person, aside from the fact that it doesn't say anywhere in the Constitution that he has the power to pardon a person, but it is because the whole power of the president to commute or pardon an individual's punishment is basically, it flows that he speaks on behalf of the states, and he basically has to have the understanding, the logic, the knowledge as to what it is he's pardoning. That's part of the idea, is that he has to know what it is he's pardoning. And if he has no idea, if he thinks this person committed 6 crimes and it turns out he committed 6,000 crimes, and he says, well, I'm just going to pardon you on everything, that he might not even want to pardon him on crime number 348. He's like, I didn't know anything about that. So how could his words be used to take as just a blanket for anything that ever happened the last 10 years or whatever, the way he did with Hunter Biden? That's why I think that the pardon of Hunter Biden, assuming it's a valid pardon or commutation, irrespective of irrespective of an issue with whether or not he signed it. Because if he didn't sign it, as long as he knew about it, it should be, to my mind, it should be valid. And you can't prove that he didn't know about it. It'd be almost impossible to prove that he didn't know about it, that Biden didn't know that this pardon was going out. You're going to really, really struggle to prove that if you're a prosecutor. I don't even know how the hell you ever would. It could be a phone call that he says, yeah, pardon him. It could be someone walked into his office, says, you want to pardon him? Yeah, pardon him. And then someone else signs for him. That, to my mind, should be legal. So just because it's an auto pen, I don't think that that's going to invalidate any of these pardons, unless you can show he really didn't have cognizance. But good luck with that. Because as we all know, Biden was in and out day to day. How do you know he was out on the day that his brain wasn't locked in on that particular, for those particular 3 minutes when he said to pardon Mr. X or Dr. Fauci or the January 6th Select Committee? You don't know. So that's why I don't think that the auto pen is going to be effective in that regard. However, I do think that it ends up being I don't think that it's effective with respect to pardoning a person or all their blanket crimes. I don't think that that's legally valid. I don't think it does anything. It shouldn't do anything. But prosecutors see it. And they're like, and a lot of prosecutors, I think that it ends up being de facto, meaning as a matter of fact, it pardons them, it protects them, even if de jure, as a matter of law, it doesn't. What does that mean? It means, well, they never get charged because the prosecutor's like, well, there's a pardon out there. What am I going to do? I can't do anything about this. What am I going to do? I can't do anything. No. But if they would charge it, and it went up to the Supreme, and what would happen at that point? The guy would waive his pardon. I got a pardon. I got a 10-year pardon. Anything I did with COVID-19, pardon. Now that would go to the appellate court. First it would go to the circuit, and then it would go likely to the Supreme Court. Trying to assess, is this a valid pardon or not? And I think that the Supreme Court should come to a conclusion that no, it's not a valid pardon. So I do think that, and for all the reasons I laid out earlier, I think that that should be the legal conclusion. So it ends up working as a pardon because he doesn't get prosecuted, but it shouldn't. And some prosecutor one day, sometime, hopefully in the very, very near future, will test the validity of these blanket pardons. And I would say that the court should come out like I'm saying right now. Now, unfortunately, some of the sage minds in the Supreme Court, we can question what kind of deep thinking we have from the likes of, I don't understand Justice Brown Jackson, so whether she'll come to a proper conclusion, who the hell knows? But that's what the court should find, and they have no opportunity to find it until some prosecutor decides to prosecute someone who's protected by a blanket pardon to try and show that it's not any protection at all. Anyhow, so he does have this blanket pardon right now. So even if Dr. Moran's was referenced, the indictment is referencing Dr. Moran's working with Dr. Fauci, unless Todd Blanche has the cojones to try and pierce that blanket pardon of Dr. Fauci, he'll never be charged.
Morans, who served as a senior advisor to Fauci from 2006 to 2022, conducted official government business from a private email account and asked the National Institutes of Health's FOIA liaison for tips on how to evade records requests. In an email from February 2020,
he's asking, how do I get around these requests? They want to know all this stuff that I sent to you guys. All our conversations about how we started this freaking thing.
Morens wrote, I learned from our FOIA lady here how to make emails disappear after I am FOIA'd, but before the search starts. He later went on to write that he, quote, deleted most of those earlier emails after sending them to Gmail. 2 months later, in April 2021.
Wow. These are damning admissions. This guy has problems. This guy has serious problems.
Morens also wrote, there is no worry about FOIAs. I can either send stuff to Tony on his private Gmail, or
Tony obviously being Anthony Fauci,
or hand it to him at work or at his house. He is too smart to let colleagues send him stuff that could cause trouble.
Wow. Oh, man. We need to go after Tony. What was the name of that comedian who made that Puerto Rican joke? I want to be clear. I'm not issuing a threat to Dr. Fauci. I have no intention, and I don't want any of you to actually cause harm to Dr. Fauci.
In September 2021, Morens wrote that he would, quote, always communicate on Gmail because my NIH email is FOIA'd constantly. And
he's so stupid.
Quote, delete anything I don't want to see in the New York Times. Morens oversaw a now infamous grant from the NIH to the Manhattan-based nonprofit EcoHealth Alliance, beginning in 2014, that ended up funneling U.S. taxpayer dollars to the Wuhan Institute of Virology for bat coronavirus research. Acting Attorney General Todd Blanche said that the allegations represented a, quote, profound abuse of trust. As alleged in the indictment, Dr. Morens and his co-conspirators deliberately concealed information and falsified records in an effort to suppress alternative theories regarding the origins of COVID-19. Government officials have a solemn duty to provide honest, well-grounded facts and advice in service of the public interest, not to advance their own personal or ideological agendas.
So there you go. That's a nice little synopsis of it. I am going to pull up the indictment here, and we'll skim through it just because I started working on it. We're going to do this as quickly as I possibly can. Now, I will tell you that this comes up in the District of Maryland. A lot of you are going to be cynical about that, and properly so, assuming there's going to be a whole bunch of lefties who are going to be standing up for these crooked doctors. And in my opinion, they are very crooked. But it's United States District Court, District of Maryland, U.S. versus Morens. We'll break this down, as I said, relatively quickly. David Morens, co-conspirator 1 and co-conspirator 2, and others defrauded and committed offense against the United States. And here's your background. So you have NIAID is part of the National Institute of Health of NIH. So in case you don't understand the structural makeup here, you have NIAID, and part of that, and that's part of, underneath NIH. NIH is part of HHS. NIAID was responsible for identifying and responding to emerging public health threats. Morens resided in Montgomery County, Maryland. He was working there during this key time from 1998 to 2021. And among other things, his tasks included advising on senior level policies, developing recommendations and solutions to issues impacting NIH. Morens was responsible for advising senior NIAID official 1 for meetings with officials from Congress, the White House, NIH, HHS, and other federal agencies. We also have here that as senior advisor, Morens gathered information from grantees and others, scientific community, to establish facts regarding the nature of COVID-19. And he authored and co-authored numerous papers. Now, co-conspirator 1 was the president and the CEO of some company during this relevant time, basically up until January 2025. He lives in New York. Company One, what is this company? Is a nonprofit with a stated mission of protecting people, animals, and the environment from emerging infectious diseases. And Conspirator One researched the origins, transmissibility, virility, and impacts of potential emergent infectious diseases, including those associated with coronavirus. On May 27, 2014, NIH awarded grant number, who cares, for understanding the risk of bat coronavirus emergence. And co-conspirator one was the project director and principal investigator for the bat coronavirus grant. And the Wuhan Institute of Virology, which is obviously in China, received a sub-award from Company One. So Company One gave some of the money that they got to the Wuhan Institute. Co-conspirator two, an individual known to the grand jury, was a physician, scientist, and professor who worked for an academic institution that also received grant monies from NIH. Congress enacted the FRA, the Federal Records Act. The FRA governs the creation, management, and disposal of federal records by agencies. So this is, it seems like a very well crafted indictment. You can tell they invested some serious time in this, because this is how, if you're interested in how legal drafting is, it's always easiest when you build a solid foundation that just sort of it becomes much more digestible when you break down all this stuff in the background. And they do a very good job of breaking down. Okay, this is who he is. This is what the objective of these statutes are, the relevant statutes. In accordance with federal law, HHS established safeguards against the removal of or loss of federal records because they need to comply with FOIA requests. Safeguards include that records in the custody of the agency are not to be alienated or destroyed, and also tells you the penalties provided by law for the unlawful removal or destruction of records. So they have these safeguards in place. NIH provided yearly training on its employees' obligations with respect to the Federal Records Act. And according to the training Moorings received, the interactions between NIH and its staff with the public and other federal agencies are captured through federal records. He was instructed that if information is materially facilitated agency business, then it was a federal record. So he knows that this becomes a federal record. He was also informed that federal records could be in any form or medium, and the property and it's not his. It's considered property of the federal government. So you can't just do whatever the heck you want with it. Those are considered now like it's not your possession. You can't be like, well, I wrote it, it's mine. No, it becomes a federal record. And that employees are required to store federal records in agency-approved record-keeping systems. He also knew he had to send stuff through NIH email, and he's not to use his personal email account to conduct NIH business. So these are all things that he was trained in to be aware of what it is that he is obligated to do. Within the NIH, most federal records were temporary records that could be destroyed after a required holding period. Then you have to manage disposal of email records, the NIH adopted the capstone approach. For non-capstone employees, such as Moorings, the holding period for emails was generally 7 years. So he's supposed to be holding on to this for a very long time, 7 years, which we're still in that 7-year period now, believe it or not. The NIH, however, was required by law to suspend any destruction of records responsive to a Freedom of Information request until the request was satisfied. So it's even longer than that once you get a FOIA request. Any email deleted or removed from the email system before the 7-year minimum retention was an unauthorized destruction or removal of a federal record. So we can get them for anything of that. HHS implemented FOIA for HHS records, and HHS administered FOIA with a presumption of openness. A FOIA officer was an HHS official who had been delegated the authority. FOIA officer for NIAID was responsible for receiving FOIA requests, distributing them, and In a period between April 2020 and December 2022, NIAID received hundreds of FOIA requests related to COVID-19. Many sought access to communications involving Morons. And these are some of the stuff that was requested. Judicial Watch made a request, Science Magazine, some other individual on September 8th, U.S. Right to Know, the Whistleblower Protection, the Heritage Foundation, another individual on July 2022. So here's all the requests that came in there, which get processed to him. Beginning in January 2020, Morons and co-conspirator 1 began communicating about the emerging coronavirus in China. So they're having all these conversations. And on about January 9th, Morons sent an email using his official NIH email account, which is dmorons@nihd.nih.gov. In case you're interested in emailing him yourself today, he probably still, I don't know if he still has it. He doesn't work for NIH anymore, so maybe he doesn't. He probably doesn't have it. Others were inquiring whether co-conspirator 1 and others had any inside info on this new coronavirus that isn't yet in the public domain. That same day, on or about January 9th, 2020, co-conspirator 1 responded that he had lots of information and referred companies one coronavirus grant specifically focused on China. He's like, hey, this is our baby. We know all about this one. This is, again, this is January 2020. If you're wondering on the timing of all this stuff, China was dealing with the coronavirus in November into December in Wuhan, China. It first gets to America in around February that's when the first, I think, reported cases came in, February 2020. And we're in lockdowns by March. Mid-March is when we go into lockdowns of 2020. On or about January 27, 2020, co-conspirator 1 emailed bullet points about Company 1's back coronavirus grant to Morons at his NIH email account. So he's getting stuff in there on that account. And the reason he sent him was that he might relate to senior NIAID official 1 for public use, starting a few things for your information and hopefully to pass on. So he knows he's supposed to be sharing this and that this is all part of official communications. This is not just a bunch of friends schmoozing. Same day, Morons responded from his NIH email account stating in relevant part, I will pass this on to senior NIAID official 1. He then emailed the information provided to him by co-conspirator 1 to senior NIAID official 1 through senior through the official's chief of staff. Now we get to February 2020. Morons wrote about coronavirus as part of his NIH duties, because that's what he did for a living. Morons used his NIH email account to participate in an email chain with co-conspirator 1 and NIH colleagues to suggest publications on topics related to the outbreak of COVID-19. This included, according to an email from Morons and co-conspirator 1 and other NIH employees, timely commentaries about key aspects of the coronavirus situation, things that are from 30,000 feet, broad perspectives, and publishable. He's authoring articles. On April 19, 2020, he issues a letter notifying Company 1 that he's reviewing allegations that the Wuhan Institute of Virology released the coronavirus, because people were starting to say it, like, hey, you know, because as Jon Stewart aptly pointed out, if you find an outbreak of chocolatey goodness in Hershey, Pennsylvania, you kind of have like an inkling as to where it might be coming from. While it reviewed the allegations, NIH instructed Company 1 to cease providing any funds from that grant to Wuhan Institute of Virology. On or about April 24th, he emailed co-conspirator 1 a letter notifying him that NIH had elected to terminate the grant. So they're getting rid of that. Like, we're a little embarrassed by what's going on here, so we should really get rid of the grant. Why are you terminating the grant? Why are you terminating the grant? It's because they knew. They knew it came from the Wuhan Institute. Co-conspirator 1 forwarded the termination letter to co-conspirator 2. So now when you're terminating the grant, if people see you're terminating the grant, they're like, oh. And if you recall, the whole message we were getting was that coronavirus came from bat soup. That's what everyone was claiming in 2020. They were claiming that in 2021. It was like 2023 till they admitted it. We spent years with the whole bat soup theory. Well, before we were even in lockdowns, they knew it came out of the Wuhan Institute of Virology. That's why they're canceling everything here. Company wanted to apply to NIH for funding of Emergency Infectious Diseases Regional Center, a grant worth in excess of $7 million. The EIDRC grant had not yet been awarded. So obviously, the motivation that one would think they have here is they want to get a $7 million grant. So they have 7 million reasons to try and hide that they might be at fault for this emerging coronavirus. Beginning in around April 2020 and through at least until about June 2023, the defendant, now during this 3-year period, knowingly and willfully conspire and agree with co-conspirator 1 and co-conspirator 2 and with others known and unknown to the grand jury. You start to think to yourself, these co-conspirators, it sounded like Anthony Fauci, right? It sounded like, or who he calls Tony. To commit offenses against the United States, namely to commit violations of 18 U.S.C. 1519, whereby Morin's co-conspirator 1 and 2 and their co-conspirators knowingly destroyed, concealed, and covered up record, document, and tangible object with the intent to impede, obstruct, and influence the investigation and proper administration of a matter within the jurisdiction of the Department of Health and Human Services, National NIH, and NIAID. To commit offenses against the United States, namely to commit violations of 18 U.S.C. 2071, whereby Morin's co-conspirator 1 and 2 and others willfully and unlawfully and with the intent to take, conceal, and remove, mutilate, obliterate, and destroy, and intent to do so, a record, paper, document, and thing filed and deposited with the public office of the United States. Also to commit offenses against the United States, namely to commit violations of 18 U.S.C. 201. These are very serious charges, whereby co-conspirator 1, a federal grantee, directly and indirectly gave, offered, and promised things of value to Morin's. So he's basically being bribed, who directly and indirectly demanded, sought, received, and accepted to receive or accept anything of value otherwise than as provided by law for the proper discharge of official duties. For and because his official acts performed to be performed by Morin's. And defraud the United States. How so? By hamper, hinder, impede, and obstruct by craft, trickery, treachery, deceit, and dishonest means the lawful and legitimate functions of HHS, as well as NIH and NIAID. How so? What did they do? It was part of the conspiracy that Morin's and co-conspirators 1 and 2 and others, known and unknown to the grand jury, would use Morin's personal non-government issued email account to create, transfer, and exchange federal records and that pertain to Morin's responsibilities as a senior advisor to NIH. The federal records created, transferred, and exchanged through his personal non-government issued email address included the following types of records: controlled NIH work product, records concerning efforts to influence NIH to fund Company 1, records concerning Company 1's back coronavirus grant termination. So we got to get rid of that. We don't want anyone to see that stuff because that's going to, the money flow is going to stop as soon as they see that we stop that one. Records concerning public writings on the origins of COVID-19. So we got to just delete. Just click, get rid of everything. Records concerning congressional oversight of NIH. Records concerning Morin's access to senior NIA official 1 and his use of that access to convey information on behalf of Company 1. Morin's co-conspirator 1 and co-conspirator 2 and others known and unknown to the grand jury concealed, removed, destroyed, and caused the concealment and removal of federal records to evade FOIA and FRA. And that's really the meat and potatoes here. That's what they were doing. The Morin's co-conspirator 1 and 2, they concealed the communications so they could utilize his stature within the scientific community as a senior advisor to NIH for the purpose of advancing the interests of the company one. So he was being handsomely rewarded for basically duping NIH. Morin's co-conspirator 1 and 2 and others known concealed their communications so they could communicate with others in the scientific community in support of Company 1 and publish papers, articles, and other writings. Morin's co-conspirator 1 and 2 and others known and unknown to the grand jury policed the use of his government-issued email by reminding Morins to avoid communicating using his government-issued email, even though he was required to use that email. They said, hey, don't use that, use your personal one, and explicitly requesting that those contact Morins do so through his non-government issued email in order to try and circumvent all the questions they knew would be coming. These people are such slime. Oh my gosh. Oh my gosh. I don't know why we have co-conspirator 1 and 2 rather than having these people all be indicted. They're such slime. They're such slime. Conspirators 1 and 2 and others known emailed information to Morin's non-government issue personnel to relay to senior NIAID official 1 while instructing Morins to use means of communications that would help him evade the FOIA search, any FOIA search. They shared facts, press reports, and the origin of COVID-19 and Company 1 information regarding the administrative proceedings on the back coronavirus grant, information regarding congressional inquiries and activities related to COVID-19. So they're trying to hide it from Congress too. And their back coronavirus grant. And that he was basically bribed to do so, receiving things of value. Here are your overt acts. And furtherance of the conspiracy and to affect the objects thereof, at least one of the co-conspirators committed or caused to be committed at least one of the following overt acts. Exchanging emails and took actions directed in whole and part towards ensuring written communications between them related to government business would not be available to HHS, NIH, or NIAID. How they do that? They did that by basically dealing with Morin's Gmail account instead of his regular business account. And here are examples of email. The following emails were all sent from or received by Morin's exclusively on his Gmail account. And they go through a list of all these different communications, which clearly should have been used through his official account, but they avoided using his official account in order to circumvent FOIA requests. On or about April 25th, 2020, when they learned about the cancellation of the back coronavirus grant, he forwarded his communications with co-conspirator 1 and 2 from his NIH email from his account to his Gmail account, which is not supposed to do. He then emailed co-conspirator 1 stating, "This is sent from my Gmail account. Please send all replies here to Gmail. Don't send them to my official account, which is going to be investigated. Send them to Gmail." What an idiot. You're a doofus. Oh, I'm so glad to see this guy go down. He is going down. I think he's going down. Now, he might plead out. And hopefully, if he pleads out and gives us Dr. Fauci, I'd be willing to give this guy a relative slap on the wrist if we can get Fauci. There are things I cannot say except NIAID official 1 is aware that I've learned that there are ongoing efforts within NIH to steer through this with minimal damage to you and colleagues. He's done. He's totally done. I agree with you. If we can't catch idiots like this guy, if we can't catch this guy, if we can't get this guy. And that's the $1 million question, Kimmy. If it has to be Fauci. I mean, Fauci has to have known about this. If he doesn't know about it, I got more questions. How the hell could you not know about this? Uzelian is saying the reason you have 1 and 2 is I'm fairly sure they took plea deals to go against Mormons to make the case even stronger. Why would they go after Mormons specifically more than the 1 and 2? Because they're the real beneficiaries here. Mormons is being bribed to go along with it. On April 26, 2020, co-conspirator 1 wrote to Mormons and co-conspirator 2 with copies to others. Dave will communicate with you via Gmail from now on. On April 28th, more FOIA is on the way, this time to NIAID, including emails to us, alerting his group that they're targeting senior NIAID official 1 and looking for email to us and others regarding Wuhan, because they knew that all these questions were coming about Wuhan. On or about May 3rd, 2020. This is all the way at the very beginning. You know, this is on May 3rd, 2020. We're still in lockdowns. Morons emailed members of prominent professional medical organizations to enlist them in speaking on behalf of co-conspirator 1 and 2 because the termination of the grant. They wrote, colleagues, I need to keep this correspondence off of U.S. government emails for obvious reasons, so I'm sending from Gmail. I am under multiple FOIAs already. It's so stupid. How stupid can you be? You know, I think part of it might have been, by the way, it's hubris. On or about May 15, 2020, Morons emailed co-conspirator 1 falsely saying that the NIA FOIA officer had told Morons that he could cover his rear by deleting emails and making use of FOIA delays, and that he would soon need to train himself to use only Gmail. So dumb. On about May 16, Morons emailed co-conspirator 1 about an email Morons was drafting, in part to co-conspirator 1 and company 1. We all agree that we want to keep it off of it, any fingerprints of you and the North Carolina scientists and any company 1 colleagues. I need to keep this off government email and government phone texts. On July 2nd, co-conspirator 1 in Outlook, delete or send to Gmail. Delete, 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 delete. It goes on and on. On and on. More admissions about FOIA requests. David, I'm using your Gmail address to keep you out of the FOIA targets. On about February 23rd, Morons and co-conspirator 2 exchanged emails under the subject line briefing, where co-conspirator 2 told Morons to pay attention to the email address you use. This is 13th one over here. Received a huge FOIA yesterday seeking any and all document emails that mention the words Wuhan, Institute, or WIV. Your names will not show up in this FOIA, at least not from my info. On June 17, 2021, Morons in an email with the subject line, confidential within our small group, please, emailed co-conspirator 1 and 2 and others stating that he received production requests from 5 U.S. senators. Uh-oh. The Senate's coming after us about some of the issues we've been dealing with over the past year, focusing on the origins of COVID-19 and the termination of NIH's major SARS-CoV-2 grants. Morons added that he had retained very few documents on these matters and continued to request the correspondence on sensitive issues go to his Gmail. So this is his intent to try and circumvent. You have intent, you have everything here. October 5th, Morons emailed co-conspirator 1 that FOIA picked up an email he had sent conspirator 1. He said, I deleted that email, but I now learned that every email I got since 1998's caption will be turned over. Oh, no! Oh, no! Everything's captured. I thought when I hit delete, it goes away. Whether or not I instantly deleted it, Gmail, phone, text, I need to be scrupulously rely on these exclusively. Stop with my government stuff. It's all there forever. I can't delete it. Oh no, what are we gonna do? What are we gonna do? You can tell that the freak out was happening. Oh my God. On about October 6th, why would you, if you can actually dig up these emails, why would you need to have co-conspirators 1 and 2 just go through their email chain? You can see all this stuff. I don't get it. I don't get it. I don't understand. I missed this that came in, by the way. I'm just going to pause and catch up on chats just so we can, because the time is running on whether or not we're going to hit our goal tonight. It's getting close, because I got another one from J.H. Schwalbach. He says, in Yiddish, a term for a houseboy or a young assistant serving Joe Neerman is a Heusbacher. Really? Did you ever hear the term Heusbacher? The phrase is a combination of Yiddish Hebrew words where Heus related to house and Bacher meaning a young man or boy. It describes a young man charged with tending to Joe's needs. Govea Branca you. All right. Okay. All right. Well done. That was another $10 tip. If you're wondering, by the way, where we're at on our goal, I'm going to give you that third hour. If we hit that goal in that third hour, I'm going to be doing more manifesto work. I'm going to be sharing with you just how badly Mamdani is destroying the finances of New York and just what dire straits they're already in. They're already like drowning, and be assessing for you just how terrible this situation is for them. That's if we hit our goal. If you're wondering where we're at on our goal, which is a reasonable thing to be wondering, you should be wondering that. To me, it looks as if right now we are at 9. So we basically need like, I'll even count it as 10. We got 5 more. We'll be good to go. We'll see. We'll see if it happens. The email subject line, first batch of emails with David Morans. This is October 6th. It's almost as if their entire time is spent trying to figure out how do we cover up our email trail. October 6th, I will massively increase my scrutiny of all emails that come from David or CC him to make sure the NIH address is replaced by his Gmail from now on. Really important. When we get up to T, by the way, well, that's number 20. This is item number 20. On about October 27, 2021, and note to himself, Morin's emailed NIH account a contentless email saying Gmail signature remove NIH. November 18th. Please pass this on to co-conspirator 1. I ask you both that nothing gets sent to me except to my Gmail, and make sure that what gets sent to my Gmail doesn't have a CC to another government employee who could be FOIA'd. So now actually admitting that, in case there was any confusion, we have to be avoiding FOIA. We have to avoid FOIA. Keep all communications like this on private email so it can't be retrieved via FOIA. Between on or about September 15, 2022 and on or about September 18, 2022, that Morans and his 2 conspirators over here participated in an email exchange regarding a FOIA request, PDN, pre-disclosed notification contact. So it's 23 different communications where he's basically admitting that he's trying to keep things hidden from the public illegally. Morans and his 2 conspirators and others used his account to create, exchange, and conceal federal records, including to pass non-public NIH information and back-channel information to senior NIH official 1, as set forth below. Except where specifically indicated, the following emails were all sent from or received by Morans at his Gmail account. And they go through a list of these emails, which all contain information that should have been sent to his government to his government email and didn't. I don't need to go through these in great detail, but they list off 6 so far, 7. It might best connect you to it in an off-the-record manner as we're getting FOIA nonstop, so it most important that senior not have anything on the record that can come back to bite. He's so cooked, this guy. Even saying when it's not sending emails, send him stuff on, share stuff on screen on Zoom. Just don't email. And so they start listing off all the different communications that they had that were designed to circumvent. Each of these is its own punishment, which can get 20 years for each of these. This guy's facing facing potentially hundreds of years in prison for this. These are serious charges. This guy's going to die in prison unless he cuts a deal. On or about October 26, 2021, co-conspirator 1 submitted and caused the submission of a letter to NIH Director for extramural research containing Morin's suggestions, including the explanation why Company 1 failed to timely submit its 5-year report. Morin's used his senior advisor, his role as senior advisor to senior NIA official 1 to engage in official acts favorable to co-conspirators 1 and Company 1. 4, because it's such unofficial acts, some of which are identified above and behind the scenes shenanigans, co-conspirator 1 provided and promised to provide things of value to Morin's, which Morin's received and agreed to receive. I assume things of value is certain extra monies that he got, that they basically were paying him to use his private email. And here's more things they sent. Let's win this anti-science battle, get you refunded and Uber funded, and then settle scores and kick some ass. So some ass is getting kicked, not by you. Not by you. It's your flabby ass that's getting kicked. On about June 25th, June 2020, co-conspirator 1 gave Morin's 2 bottles of the Prisoner Red Napa Valley wine from Bounty Hunter Rare Wine and Spirits, which she was delivered to Morin's residence in Maryland. The wine included the following message from co-conspirator 1 to Morin's. This is the first of what I hope will be a continued series of expressions of gratitude for your service, support, and behind-the-scenes shenanigans in my battle against your boss's boss, his boss, and the ultimate boss on the Hill. Meaning Trump, because this is June of 2020. And it takes courage and commitment to do what you've done, given your job and the vindictive nature of the administration. I am eternally grateful for that, and I hope that you'll be able to return the favor one day in the meantime. Yes, burner phones would have been a lot smarter. A lot smarter. Deke Ed saying, maybe mention you are a cult leader in the manifesto, also outro in Yiddish. I don't speak Yiddish. That's the problem. I don't speak Yiddish. I struggle in Hebrew, and I don't speak Yiddish. Also on June 25th, 2020, upon receipt of the wine, Morin's emailed co-conspirator 1 from his Gmail saying, thanking him for the wine and saying, now I'm actually going to do something to deserve it. Let me think. June 26th, co-conspirator 1 emailed Morin's in his Gmail account promising additional things of value, saying, consider this my phase 2 gift. Phase 3 might actually involve a meal. The Michelin star restaurants are opening in Paris, DC, and New York. Will do eventually. So these are the things of value that he got. So it wasn't actually bribes. It was lavish gifts. On or about July 3rd, 2020, Morin submitted and caused the submission of a scientific commentary to a prominent medical journal for publication that advocated COVID-19 emerged from nature and not from a lab, of course. Morin's was listed as an author of the scientific commentary. Scientific commentary was to benefit Company 1 and co-conspirator 1 and was funded in part by the intramural research program of NIAID and NIH. So here they are with their stupid, stinking lies. really do think it was Fauci. On or about October 6, 2021, an email with the subject line, second batch of emails possibly FOIA, co-conspirator 1 email Morin's at his Gmail account to identify emails sent from Morin's NIH account that may cause issues. We got to worry about some of these if they were disclosed to the public via FOIA. In the email, co-conspirator 1 specifically referenced one email where co-conspirator 1 had sent David a bottle of wine. But no, it's absolutely cut and dry that this happened, but it gives that impression. It's not absolutely cut and dry that this happened, but it gives that impression. Counts 2 and 3, destruction, alteration, and falsification of records. So we say he knowingly altered, destroyed, mutilated, concealed, cover up, falsified, or record document. Here's some of the stuff that he burned. 1, 2. Counts 4 and 5 out is concealment, removal, or mutilation of records. And that David Morin's willfully and with intent to take, conceal, remove, mutilate, obliterate, and destroy, attempt to do so. Email correspondence of co-conspirator 1, Morin's, and others related to his official government business. Email correspondence and others related from other their business dated October 24th. And there you go. That's your true bill. This guy is so cooked. He is so. This one, look. When I tell you, when I think something looks strong, when something looks weak, this one looks. This guy Morin's is going to jail. He's going to jail. It's going to be hard for them to botch this one. So he is going to jail. 2, 3. I think we're a little short tonight. I'm feeling like we're a little short tonight. That's okay. All right. But I'll tell you this. The real question is Fauci next? That's really what the real question is. Is Fauci next? Look, if Fauci is one of these co-conspirators, then the question is, why are these co-conspirators not named? Does Todd Blanche seem like the type of person who's going to try and challenge the legitimacy of a blanket pardon? I don't know. This guy is so evil. He's so evil. I want to give you a clip just when I'm talking about Anthony Fauci so you can appreciate. This is what he said 9 years ago when Trump was first taking office for his first term.
I've spoken at after-dinner speeches and intra-dinner speeches, but I've never
gave this speech in Georgetown.
Never spoken to a line of people waiting to get their food. So it's nice to have you. Anyway, it's the idea that we are now a few days away from a new administration.
This is right before Trump is coming in.
Obviously prompted the really extraordinarily, very enjoyable, and I'm really pleased I had the opportunity to listen to the panel, both of Amy and Ron, and as well as Bill and Dr. Jafari, which really, I think, set the stage for so many of the things that we are going to be dealing with over the coming years. Given, as you heard from the introduction, that I have been around for a while and have had the opportunity and the privilege and the pleasure of serving in 5 administrations.
5 administrations. Unbelievable. So he served under Obama, Bush, Clinton, Bush, Reagan.
I thought I would bring that perspective to the topic today, is the issue of pandemic preparedness. And if there's one message that I want to leave with you today, based on my experience, and you'll see that in a moment, is that there is no question that there will be a challenge to the coming administration in the arena of infectious diseases, both chronic infectious diseases in the sense of already ongoing disease, and we have certainly a large burden of that, but also there will be a surprise outbreak. And I hope by the end of
He's predicting in 2017.
my relatively short.
He's predicting in 2017 that there's going to be a surprise outbreak for this administration. That's what he's predicting. That's what he's predicting. I don't know. He's predicting. Now he claims he has all sorts of justifications for why that's going to be that he's going to explain. And I haven't watched this entire thing.
Short presentation, you will understand why history, the history of the last 32 years that I've been the director of NIAID, will tell the next administration that there's no doubt in anyone's mind that they will be faced with the challenges that their predecessors were faced with. So
the predecessors were faced with? Were any of them faced with what Trump got? Any of them? Any of them? Fauci, you sorry dog. This guy, no, he's the sorry dog butcher. This slimy human being, long before he was killing people and forcing them to be injected, and I do think that he's responsible for their deaths. He's responsible for every one of the COVID deaths. This slimy human being, I've told this over before. If you don't want to hear it, what I'm about to describe is very gross. But you need to understand just how gross this human being is. He experimented on beagles. You can look this up. I'm not making this up. This is going to be gross. I'll hold my hand up here in case you don't want to listen to something that's disturbing, because this is very disturbing, okay? So I'll put my hand down when I'm done. So it'll take me like 60 seconds to explain this. He was experimenting with beagles, that he would keep their eyes stuck open and have their eyes be eaten by sand fleas, bugs eating the eyes of beagles. That's living beagles. That he would basically have their eyes being devoured by bugs. The screaming from the dogs was so disturbing to the scientists who were monitoring this experiment that he cut out the vocal cords from the beagles so that their screaming and whimpering in pain would not be too disturbing to the people who were engaging in this experiment. That's what this lunatic did. So he didn't just have them torture them by having bugs eat their eyes while they're alive. He made sure that no one would have to be troubled by hearing their screaming by basically saying, let's cut their throats, to the point that they're still alive but can't even scream for help, scream in pain. This guy is a sick monster. How someone comes up that this is something, I mean, you talk about just unbelievable. Unbelievable. How it is that this guy is overseeing the health of every American for decade after decade, not to mention the complete ridiculous farce that he did with AIDS. Unbelievable. This clown, this joke, was then put in charge of, likely, in the opinion of many people, and this is not established fact yet, unleashing COVID on the world with the objective of trying to remedy it. And the remedies, in many cases, were far more onerous and painful and destructive to the millions of people, if not potentially, I don't know, billion people worldwide who were injected with all these tested vaccines that he got ridiculously wealthy from. He's a sick monster. I'm very confident that when this guy meets his maker, I don't know if he's going to get to meet his maker. And when he closes his eyes for the last time, And frankly, justice would be as if he dies with his eyes open and had some field somewhere and has his eyeballs eaten out. Or better yet, better than that, he should basically be like find himself. I hope this guy finds himself paralyzed with his eyes open and has his eyeballs eaten out by bugs. He's left alone somewhere and bleed out and die. And when he breathes his last breath of fresh air, I am very confident that new depths of hell will be opened up, drop beneath this guy, and he'll fall into Sheol. Horrible, horrible human being. So, yeah, I'm not a fan. I'm not a fan. Anyway, that's what I got for you. That's what I got for you tonight. We have here Deke. Welcome to the following. God bless you, brother. Following is not at all a cult type of cult. It's just not. It's just a gathering of like-minded individuals who are seeking greater personal growth through community, unity, learning, and thinking. And so welcome aboard. And I'm also not at all the leader of the following. I'm just a host. If you're here, I'd appreciate if you could like and subscribe. Derna says, remember that old own the left used to use about Fauci that he literally wrote the textbooks? He did, while he had the authority to issue grants. Sounds like graft, influence peddling, and bribery. This guy was the most crooked person. I'm sure he's a billionaire. He's so evil. So bloody evil. Luzellen says, Joe, did you see the High Quality Learning Center got raided? I was thinking about covering that. Yes, I did. I did see that. He shares a link here with me. How long is your link? I did see that. Was actually, I had all these different things I was planning on throwing in as a little side bonus. I said, I opened the show, you might recall, I think you were here in the beginning. I opened the show by talking about how I feel like I'm always talking about Minnesota, but they were raided. It's true. But this, you didn't give me like a little, you gave me a link to an article rather than like a video. If it was like a 2-minute video, I would have probably shared it. But I really don't want to start reading this story now. I really don't. I don't know, maybe we'll cover it tomorrow. We'll see. Maybe we'll cover it tomorrow. It seems we came up a little short tonight, but that's okay. That's okay. I'm feeling a little tired anyway. So tomorrow evening, we will have Sin in the house. That's right. Our good friend Sin will be joining me. And yeah, you should be here too. It's likely to start at 10 p.m. Follow me at goodlogic.locals.com, goodlogic.locals.com, so you know when and where I will be. You never have to worry about like, oh my gosh, I'm missing Joe. Not everyone can get a text message from me the way JH does. I can't. I did ask him if he wanted a text message on what time I'm starting. And he said yes. So I did. I don't know if I'm going to send him one every day. I don't know about that, JH. We'll see. We'll see. Anyway, I am going to remind you, but unfortunately, we did not quite meet our goal tonight. So, but tomorrow's another day. And I hope you will see me then at that time. Until then, I thank you all for joining me. Remind you that lab meat was never, ever, ever meant for you. It wasn't. It's meant for they, them. All the they, thems out there, they're the ones who are supposed to be eating lab meat. Think about those two words and how they never should have been put as anything that should be back to back. Instead of being farm animals, it's from a lab. And I just want to remind you, if you want to know who works in labs, you want lab meat? You want lab meat? Lab worker. Just saying. Don't do it. It's not for you. It's for they, them. It was never meant for you. And do not eat the bugs. Don't do it. Do not eat the bugs. Have a good night, everyone. As always, Godspeed.